Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 section 170.
Today, we're diving into a really crucial section of the new Bharatiya Sakshya Adhiniyam 2023. We're talking about section 170. Now, this section tackles a massive question that always comes up when a new law replaces an old one. What happens to all the legal stuff that was already in motion? Let's find out. So, think about it for a second. The Indian Evidence Act of 1872, a law that's been around for more than 150 years, is suddenly gone. This creates a huge question for our entire legal system, right? What happens to the lakhs of cases that are still going on? We're talking about trials, appeals, investigations, all started under the old rules. Do they just stop? Do they switch to the new law halfway through? Well, Section 170 is the provision that gives us the clear, definitive answer. With the Bharatiya Sakshya Adhiniyam 2023, we've officially entered a new era in the law of evidence. The old, historic Indian Evidence Act of 1872 is repealed, but you can't just flip a switch on something that's foundational. This transition has to be managed perfectly to prevent complete chaos in the courts and to make sure justice continues without a hitch. आज हम डिस्कस करेंगे Section 170 of the Bharatiya Sakshya Adhiniyam 2023. Now, for your judiciary and APU exams, this section is incredibly important. And please remember the new section number. It's 170. Quoting the old Repealed Act would be a major mistake in your exams because this new section is now the only one that governs this entire transition. So let's get into the mechanics of how this section actually works. The best way to think about Section 170 is to see it as a transition bridge. Its whole job is to connect the old legal system with the new one, making sure that the flow of justice is smooth, stable, and uninterrupted. The Bare Act provision for Section 170 is broken down into two parts. Subsection 1 is as simple and direct as it gets. It just says the Indian Evidence Act 1872 is hereby repealed. In simple language, इसका मतलब है कि पुराना कानून अब officially समाप्त हो चुका है. It's done. Okay, and now we get to the real heart of this section. This is the most critical part, the savings clause. You'll find this in subsection 2, and this is the specific tool the law uses to protect all those ongoing legal proceedings we talked about. This clause directly answers that big question about all the pending cases. So here's the actual text of subsection 2. Now, I know it might look like a wall of legal text, but it's not that complicated. It starts with a very important phrase, notwithstanding such repeal. That just means even though we've repealed the old act. It goes on to say that all pending proceedings, and that includes everything from applications and trials to investigations and appeals, will continue to be governed by the old Indian Evidence Act of 1872, as if the new law was never passed at all. That last part is the key. So in this section, there are three really important concepts you need to get. First, pending proceedings. This is basically any legal action that was already started before the new act kicked in. Second is the cutoff point. This is simply the exact date the Bharatiya Sakshya Adhiniyam 2023 officially came into force. Any case started before that date is pending. And third, the engine that makes this all work, legal fiction. So, what on earth is this legal fiction? Well, it's a fascinating concept where the law basically pretends something is true to achieve justice, even if it's not literally true. In this situation, for all those pending cases, the court will act as if the Bharatiya Sakshya Adhiniyam 2023 doesn't even exist. It's going to keep using the old rules from the Indian Evidence Act 1872 until that specific case is completely finished. This ensures that the rules of the game don't change on you midway through, which is fundamental to fairness. Now, this idea of a savings clause isn't something new or radical. It's actually built on some very old, time-tested legal principles that are all about ensuring justice and predictability in the law. Let's take a quick look at the doctrines that provide the foundation for Section 170. इस principle को एक legal maxim से भी समझा जा सकता है, and it's a good one to remember. Lex prospicit non respecit. It simply means the law looks forward, not backward. As a general rule, a new law is supposed to apply to things that happen in the future, not to things that have already happened in the past. This prevents a lot of injustice, right? You don't want something that was perfectly legal when you did it to suddenly become illegal after the fact. And that leads us straight to this really important difference between prospective and retrospective laws. A prospective law, like our new Adhiniyam, applies from a certain date onwards into the future. A retrospective law, on the other hand, reaches back in time and applies to past events. Courts generally avoid applying laws retrospectively, especially in criminal matters, because it creates so much uncertainty. Section 170 makes it crystal clear that the New Evidence Act is meant to operate prospectively. The Supreme Court really cemented this idea in the landmark case of Hitendra Vishnu Thakur versus the state of Maharashtra. The court laid down some very clear principles. It held that any law is always assumed to be prospective, unless the lawmakers have made it super clear that it's meant to be retrospective. And, most importantly, any law that messes with your fundamental, substantive rights is presumed to be prospective. Section 170 is a perfect example of this principle in action. The case of Gargapati Viryaya gives us another great example of these substantive rights. In this judgment, the court held that the right to an appeal is a vested right. What that means is that your right to appeal is based on the law that was in force when your case first started. A new law can't just come along later and take that right away from you. See how Section 170 is designed to protect exactly these kinds of vested rights? It's all connected. Okay, so we've covered the theory, now let's get practical. How does Section 170 actually work in a real courtroom? We're going to look at a few scenarios, the kind you might see in a problem-based question on your exam.
All right, let's imagine a criminal trial that started back in 2022. The new Adhiniyam comes into force in 2024. Which law applies? The old one, the Indian Evidence Act 1872. What if an appeal was filed in January 2024, just before the new act started? Same answer. It's governed by the old act. An investigation that started before the cutoff date. Again, old law. The key takeaway is this. Only a brand new case, one that is filed after the commencement date of the Bharatiya Sakshya Adhiniyam, will be governed by the new law. It's all about that cutoff date. So let's make this absolutely clear for your exams. The Indian Evidence Act 1872 is now the old law. It is repealed. The new law in force is the Bharatiya Sakshya Adhiniyam 2023. It's so important that you use the correct, new terminology and section numbers in your answers. Don't make that simple mistake. Okay, let's wrap all of this up and put it into a neat package for your exams. What are the absolute key takeaways you need to remember about Section 170 for your judiciary and APO preparations? For your judiciary prelims, you can expect a direct hit. A question like, which section of the Bharatiya Sakshya Adhiniyam deals with repeal and savings? And you'll know the answer is Section 170. Now, for your mains, they're likely going to give you a problem-based question. They'll describe a scenario, and you'll have to decide if the old law or the new law applies. And what's the key to solving it? You got it. Correctly identifying and applying the cutoff date. So for a quick revision, just burn these three things into your memory. First, the section number is 170 of the Bharatiya Sakshya Adhiniyam 2023. Second, the core concept is repeal with a savings clause. The old act is gone, but it's saved for pending cases. And third, its importance for your exams is extremely high. This is a foundational topic. So in the end, Section 170 isn't just some dry technical rule. It's really the guardian of fairness and legal stability. It's the mechanism that ensures that this huge shift from a 150-year-old law to a modern one happens smoothly without creating chaos and injustice in our courts. For more judiciary, APO, and law exam-focused legal content, please stay connected with us here at Ganga Education. Thank you for watching.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.